Testing. All right. Toxic Substance Control Act, Section 14, confidential information. In general, except as provided in Section A, administrators shall not use disclosed information except for the disclosure pursuant to subsection A, Section 552, Title 5, United States Code by reason of Section B4 of this section. 1. They're reported otherwise by the administrator under this Act. 2. The requirements of subsection C are met in any proceedings under 552A with the Title 5 of the United States Code obtaining the information disclosure has been denied because of the provision subsection administrator may not rely on subsection 552B3 of such title to sustain administrative action. B. Information not protected from the disclosure mixed confidential, non-confidential information. Information is protected with the disclosure under the section, which is mixed with the information not protected with the disclosure under if the act does not lose its protection. Disclosure notwithstanding, it is mixed with the information not protected with the disclosure. 2. Information from health and safety study with the substance section A does not prohibit the disclosure. Any health and safety study that is submitted under the act with respect to any chemical substance to make sure with the have the day of the which is such study was disclosed as an offer to the commercial distribution. 2. Any chemical substance to make sure which of the testing was required with section 4 with the notification required in subsection 5. Any information reported with otherwise obtained with the Ministry of Health safety study with relate to the chemical substance to make sure described in clauses 1 and 2 subparagraph A. Alright, the paragraph does not authorize disclosure of any of the information formats, including molecular structure for the chemical substance to make sure for the disclosed process, even in the manufacturing process, and chemical substance of the mixture, but then gave it the mixture portion of the mixture compromised with the chemical substance of the mixture. 3. Other information not protected by the disclosure subsection A that does not prohibit the disclosure in general. Information describing the manufacturer expressed specified aggregated volumes of administrative that determines the disclosure of specific aggregated volumes for the relief of the confidential information expressed in ranges. B. A general description of the process of the manufacturing and process of the industrial, commercial, for the consumer to function, give the chemical stuff to make sure of the article containing chemical stuff to make sure of the information specific to the industry or industry sector for the customarily widely would be shared by the general public within the industry and industry sector. B. Bans and phase out. In general, the administrator obligated the rule of the pursuant to Section 6A establishes the ban and phase out of the chemical stuff to make sure for the protecting disclosure of the information under the section with respect to the chemical stuff to make sure shall go with the presumed no longer subject to the G1E and paragraph B and C of this section. Limitations. Critical use. In the case of chemical substance, make sure the specific condition with the subject exemption paragraph 6G with the administrator establishes the ban and phase out with the prescribed in subsection A. The respect with the chemical structure substance make sure the presumption again for the protection of the subject paragraph should only apply if the information relates solely with the conditions of the chemical substance make sure of which exemption does not apply. 2. Exports. In case of the chemical substance that make sure for the manufacture, processing, distribution, commerce for the meeting of the conditions section 12A of the administrator established for the ban and phase out of the description of subparagraph A with respect to the chemical substance make sure for the presumption with the agents again for the protection of the any subparagraph shall not apply with the information related solely with any of their manufacture, processing, distribution, commercial, the chemical substance fixture of the condition, any substance of the ban or phase out within the life of the administrator makes the determination section 12A. Specific condition for use in case of the chemical substance make sure for the administrator establishes the ban or phase out of the description of subparagraph A. Respect for the specific condition use for the chemical substance make sure for the presumption and again for the protective in subparagraphs should only apply and information relates solely with the condition for the chemical substance make sure for the which of the ban or phase out is established. C. Request of a non-disclosure. In general manufacture process for the chemical substance make sure such for the ban or the phase out described in the paragraph may submit to the administrator within 30 days of the read and notification with the subsection G2A with the request of the including documentation supporting such for the request of the substance the information with notice applies should not be disclosed, but the disclosure should be delayed with the administration shall review the request under section G1E. 2. The effects of the non-request of the denial of the no request the non-disclosure delay submitted with the administrator on subparagraph administrators denied with the such request of the subsection G1A with the information should be protected with the disclosure of the section. 5. Certain requests. If the request is made with the administrator with the section 552A2 Title 5 of the United States Code, information reported with the otherwise determined by the administrator of the act but is not protected with the disclosure under subsection administrator to deny with the request for the basis on 552B4 Title 5 United States Code. Requirements of the confidential claim, assertions, and claims. In general, a person seeking to protect with the disclosure information person submitted with this act with include with the information described in paragraph 2 with the should assert the administrator claim with the protection with disclosure concurrent submission of information according to the subject rules regarding the claim for the protection disclosure administrator of the promulgate with the promulgation pursuant to the title. B. The inclusion assertion of the claim with the subparagraph A shall include the statement that the person has 1. Take the reasonable measure to protect with the confidential information. 2. Determine the information is not required for the disclosure of the otherwise made available to the public under any of the federal law. 3. The reasonable basis for the conclude with the disclosure information is likely to be caused of the substantial harm of the competitive position of the person. 4. Reasonable basis to leave with the information is not readily rediscoverable with reverse engineering. C. Chemical requirements for claims and regarding chemical identity information. K. The claim with the subparagraph A for the protection of the disclosure specifically chemical identity of the claim shall include the structural descriptive of the generic name of the chemical substance administrator may disclose to the public in subject to the condition of the start of the generic name shall 1. Constitute the guidance for the development of the administrative paragraph, or A. The describe the chemical structure for the chemical substance specifically practical with protecting the failure of the chemical structure. 1. The claim that it is confidential. 2. The disclosure which would likely be cause substantial harm to the competitive position of the person. 2. Information is generally not subject to the substantial requirements subject to section F. The following information should not be subject to the substantial requirements of paragraph 3. A specific information prescribed in the process of the manufacturing processing substance and mixture of the article. B. A mixture marketing sales information. C. Information to identify supplier and customer. D. In case of the mixture, detail of the fully composition of mixture and respective percentage of the constitute. E. Specific information regarding the use of the function, application, chemical substance, mixture of the process of the mixture and article with the specific production volumes of the manufacturing processors. And G. Prior to the date of the chemical substance, the author of the chemical commercial distribution, specific chemical identity, chemical substance, including chemical name, molecular formula, chemical abstractive services name, number, and other information would identify the specific chemical substance. The specific chemical identified was claimed as confidential at the time it was submitted with the notes under section 5. Alright, 3. Substantiation requirements. Except for paragraph 2, the person is certain that claim to protect information, the disclosure in a section with the substantiation of the claim, according to the rules administrator have promulgate pursuant to section 4. Guidance. The administration should develop the guidance regarding the determination structural descriptive of the generic name in the case of the claim for the protection of the disclosure of the specific chemical identity, the content of the form of the statement of the need of the agreement of the required in paragraph 4, 5, and 6 of the subsection D. 5. Certification. Authorized official of the person described in paragraph 1A shall certify the statement the requirement of the claim of the support of the pursuant of the claim 1B with the information regarding the substantial claim of the pursuant of paragraph 3 of the true and correct. The exemption to protect from disclosure information described in subsection A shall disclose the officer employed by the United States for the connection with the official duty of the person with the federal law to take for the health of the human environment for the specific law and the enforcement purpose of it shall disclose the contractor, the United States employee with the contractor. If the opinion of the administrator discloses the necessary satisfactory performance by the contractor in the United States for the performance of the work in connection with the action, the subject with the condition with the administrator may specify shall can disclose the administrator with the determine the disclosure necessary to protect the human environment against the unreasonable risk of the injury, health, environmental with the consideration confident on risk factor, including unreasonable risk of the potential exposure of the substantial subpopulation identified with the relevant administrative owner's condition of the use. 4. Shall be disclosed state political subdivision, state tribal government written request for the purpose of the administrator of enforcement law, the that any one or more applicable agreements administrator that they are consistent with the grant guidance for development under subsection C4B with the ensure the adequate and any with the appropriate measure for the adequate authority to maintain the confidential information according to the procedure that are comparable to procedure used by administrator safeguarding for the information. 5. They should disclose the health, environmental, professionals below for the federal, state agency, tribal government, and the treating physician, nursing, and non-emergency situations. Such person provides written statement as of a need, a signed written confidential agreement with the administrator subject to the condition, and statement of the need with a confidential agreement with the consistent with the guidance developed in subsection C4. B. The statement of the need with the statement of the person reasonable basis for the subject with the information necessary for the will, if the diagnosis, treatment of one or more individuals respond to the environmental release of exposure, one or more individuals diagnosed with the treatment that has exposed with the chemical substance mixture concerned with environmental relief of the exposure with the chemical substance mixture concern has occurred. See, the person will use the information for the purpose of the health environmental needs, the system of the statement, the need of the says except the otherwise authorized to determine the agreement and the persons who claim under the section with respect to the information. 6. Shall be disclosed within the of the emergency trading with the recording, responding physician, nurse agent with the poison with the control center for the public health, environmental official with the state political subdivision, state and or tribal government first responder, including individual duly authorized for the federal agency, state political subdivision, and state tribal government who is trained in urgent medical care, other emergency procedures, including police officer, firefighter, emergency medical technician, and the person requested for the information such for the condition of the such person shall A. have a reasonable basis for such that a medical, public, and healthy environmental exists, the information necessary for or will assist the emergency full diagnostic treatment, and one or more individuals have a diagnosed treated have been likely to be exposed to medicines, mixture of concern, serious environmental release or exposure of the chemical substance of the mixture concern that has occurred. B. The requested information and claim of the respect with the information under this section provide written statement of the need with agreed with the confidential agreement as described in paragraph 5 and submit with the administrator and such a statement of the need of the confidential agreement of the practical not be necessarily before the information is disclosed. 7. May discover the administrator determine the disclosure relevant and perceived of the act subject to the condition of the disclosure is made with the manner of the preserved potential extent of the practical without impairing the proceedings shall discover the information required by the public any of the other provision of federal law. 9. Should discover the required pursuant discovery subpoena each of the other court or the other judicial process otherwise allowed under applicable federal state law. All right, E. Duration protection of the disclosure. In general subsection, paragraph 2 with the subsection F3 and section 8B with the administrator shall protect with the disclosure information described in subparagraph A and in the case of the description subsection C2 with the such time the person served with the claim notified the administrator with the person withdrawing with the claim and is given without the case of the information with not project with the disclosure under the section. If the administrator becomes aware of the information that does not classify the person action disclosure under the section, in which case the administrator shall take action required under subparagraph F and G. Or B, in case of the information of other information described in C2 for the period of the 10 year of the day of the person after the claim and respect the information submitted to the administrator if the applicable before the expiration of the 10-year period until such time as the person served with the claim notified the administrative person withdrawing with the claim with the information shall not be protected with the disclosure under the section. If the administrator becomes aware of the information does not qualify the protection disclosure under the section which gave the administrator shall take the actions required on subsection E and G. F and G. Extension. In general, the case of the information of the other information is described in C2 but no later than day of the 60 days after the expiration shall be described in paragraph 1B. One administrator shall provide for the person served with the claim notice for the impending person expiration of the person requested in general no later than the day of the 30 days after the expiration period described in B1. The person reasserting relevant claims shall be submitted to the administrator. Request extension substantiating according to Section C3 do need the extension of the period. 3. Action of the by administrator no later than the date of the expiration period as described in paragraph 1B1. Administrator shall be in accordance with Section G1. Require review the request of the submitted under the clause 1. Make detrimental regarding whether the claim whether the request is submitted to continue the required relevant requirements of the section. 3A grant the extension of the 10 years denied of the request no limit of the number of the extension. There shall be no limit of the number of extensions granted over the paragraph administrator determines of the relevant request on the paragraph B1. Establishing the need for the extension of the period meet the requirements of the established by the administrative review and resubstantiation. Discretion administrator may require any proof of the claim of the protection of the information from the disclosure under the section, whether it be before, on, or after the date of the enactment of Franklin R. Lutenberg Chemical Safety Act 21st century, to reinsert for the resubstantiate claim in accordance with the section. Alright, A. After the chemical substance designated with a high priority substance under Section 6B, and the any chemical substance designated with the active substance under paragraph under Section 8B, 5B, 3. If the administrator determines the disclosures concerning the information currently protected with the disclosure would be important to the ask of the administrator for the conducting risk evaluation promulgating rules in Section 6. Review required. The administrator shall review the claim of the portion of the information disclosure of the section will require any of the person claim with the protection with the information whether before, on, after the day of the enactment of Franklin R. Lutenberg Chemical Safety Act 21st Act to reinsert, resubstantiate the claim in accordance with its selection. As necessary, the term of the information qualifies as exempt in disclosure connection from request information received by the administrator under Section 552, 505 United States Code. If the administrator, for the reasonable basis of the believe the information does not qualify for protection of the disclosure under the section, or if for any of the chemicals of the administrator determined subsection C or B4A with the pretends reasonable risk of the injury of the health environment. Period of protection. If the administrator requires the person reassert for the resubstantiate a claim under subsection determined for the claim to continue to meet the relevant requirements of the section, administrator shall protect the information with the subject of the claim from the disclosure period of 10 days of the day of the start of the determination subject to subsequent requirements of the administrator on subsection. Duties of the administrator. Termination. In general, the acceptable claim regarding information described in C2 of the administrator shall the paragraph C with no later than 90 days to receive of the claim under section C. No later than 30 days after the receipt, request the extension of the claim under section E with the request of the under subsection B4, C with the review and then approve of the proven in part with the denial of the part or deny the claim of the request of the B. The reason for the denial of the administrator, denial of the part of the claim with the request of the subparagraph A with the administrator shall provide the person with the asserted claim submitted to the request of the written statement for the reason for the denial in the part of the claim of the requests. Alright, C. Subsets. The administrator shall accept with respect with the information described in subsection C2G. Review all the requests under the section of protection with the disclosure of specific chemical identity with the chemical subset, and review the representative subset with the compromising at least 25% of all of the claimants requests for the protection with the disclosure in the section. Alright, D. Effective of the failure to effective failure to act. Failure to administrator to make a decision regarding claim or request of the protecting the disclosure extension under the shall have the non-effective denial of eliminating the claim and request of the protecting from disclosure. Alright, E. Determination required for the under subsection with respect to the request submitted with the subsection B for C, but the administrator shall have the objection and ensure the information relevant to the protection of health and environment disclosed the extent of the practical determine the documentation provided by the person rebuts which shall be presumption of the administrator of the public interest of the disclosure of the information outweighs the public proprietary interest, maintaining the protection of all the portion of the information the person has requested not to be disclosed, but the disclosure be delayed to the notification. In general, except for the provided in subparagraph B in the subsections B, D, and E, the administrator denies in the part of the claim the request of the paragraph 1 to conclude with the accordance with this section, the information not qualify the protection of the disclosure and for the disclosure information pursuant to subsection D promulgate the rules under 6A for the establishing loan ban phase out respect with the chemicals of the mixture. Administrator shall notify the written person of the server that the claim submitted with the request and intent of the administrator to disclose the information but not protect the information from the disclosure. Under the first section, the notice shall be furnished for the certified mail and return receipt required for the person to deliver other means allowed with the verification fact of the date of the receipt. B. Disclosure information except the provider in paragraph C, the administrator shall not disclose the information of the subsection until the date of the 30 days after the date of the person has served with the claim and the submitted the request to receive the notification of the subparagraph A. Exemption: 15-day notification for information. Administrator of the intent of the disclosed in the subsection D3, D4, D5, and J. The administrator shall disclose the information until the day of 15 days of which the person has asserted with the claim and submitted with the request in the notification subparagraph A, except with respect to the information to be disclosed in subsection D3, the administrator determined the disclosure information necessary to protect any of the imminent substantial harm to the health of the environmental no prior to shall be necessary. 2. Notification as soon as practical for the information administrator intended under paragraph 6 of the subsections A, D. They shall the contact or notify the person submitted with the information that disclosed as soon as practical after disclosure of information. No notification required. No notification shall not be required for the disclosure information under paragraph 1, 2, 7, and 8 and subsection D. The disclosure information for an administrator has to provide with the person served with the claim the notice on subsection E2A, and each person does not submit the administrative request under subsection E2B before the deadline established in section E2B1. Alright, appeals. Action, restraint, disclosure of the person receiving the notification paragraph of the relief of the information protected with the disclosure of the section before the day of the information with the disclosure of the person in paragraph C and B and C with the, or C, B, or C with the person bringing the action, the restraint of the disclosure of the information. The United States of the District Court for the District of the complaint reside at the principal place of the business. United States of the District Court for the District of Columbia. No disclosure in general of the subsection B of D of the administration does not disclose the information subject to appeal under the paragraph of the debate before the day of which the applicable court rules action with clause 1. Exemption subclause I shall not apply with the disclosure information described in subparagraph D for 1J. Request for the notification system administration consultation director Center of the Disease Control Prevention shall develop the request notification system format language that readily accessible and is understandable, allow the expedient specific information disclosed pursuant to paragraph 5 and 6 of subsection D. Unique identifiers administrator shall develop the system and assign with a unique identifier specific chemical identity for the administrator shall require the protection with the disclosure shall not be either specific chemical identity, structural, descriptive, generic type. 2. The apply with the identifier consistently to all information relevant to the applicable chemical substance. Any published or out-of-date list of chemical substances referred to their unique identities in which the claim to protect the chemical identity with the disclosure have been approved, including expiration date with such a claim. Ensure that the non-confidential information is received. The administrator respect with the chemical substance included with the list of the published in subparagraph B with the specific chemical identity of the chemical substance and protect with the disclosure subsection identity of the chemical substance with the unique identifier and for each claim of the protection specific chemical identity have the administrator expire with the withdrawal of the person who they serve with the claim with the administrator has used unique identifier signed at the end of this paragraph to protect the specific chemical identity information for the administrator has public and clear linking chemical identity with the unique identifier such information is extent unpractical. Criminal penalty, wrongful disclosure, individual subject to penalty in general, subparagraph C with the paragraph 2 with the individual described in paragraph B which will be fined fine under Title 18 United States Code, imprisonment for not more than 1 year. Bold description. Individual referred to the subparagraph A of the individual is pursuant to the section obtained with the possession has the access to information protected by the disclosure under the section. Nothing in the information protected by the disclosure under the section will disclose the information of the manner any of the person entered in to receive this information. Exemption. The paragraph shall not apply with any medical professionals, including the emergency medical technician, any other first responders with the code of the information obtained with the paragraph 5 and 6 of the subsection D with the patient treated with a medical professional, individual person authorized to make medical and healthcare decisions on behalf of such a patient as for the need of the diagnosis, treatment, or other patient. Articles in Section 1905, Title 18, United States Code shall not apply with respect publishing, divulging, disclosing, making known of, making available the information reported otherwise pertaining to the administrator under this act. Applicability in general, with the expect the otherwise section of the section 8 of the other applicable federal law, the administrators have no authority required substantiation resubstantiation claim protected disclosure information required reported otherwise obtained with the administrator under the act prior to the day of the enactment of Frank R. Lutenberg Chemical Safety Act 21st century, or to impose substantiation resubstantiation requirements with respect to the protection of information described in subsection A under this act. They are more extensive than they are required in this section. Alright, 2. Action with the promulgation rule of notice to the act to prevent the administrator from reviewing, requiring, substantiating, resubstantiating, improving against probably denying any of the claim protecting the disclosure information effective date of the rules applicable to those claims administrator with the promulgated the effect of the date of the enactment of Frank R. Lutenberg Chemical Safety Act, the 21st Century Act. Alright, access to the Congress, notwithstanding any limitation contained with the section of the other provisional law, information reported, otherwise provided, obtained and operated, obtained and authorized, administrator with the representative administrator under this act shall be made with available the written request of the duly authorized committee and the other Congress to such committee. Or Section 15, prohibited acts. It shall be unlawful to any of the person who failed to refuse to comply with any requirements of the title of the rules or promulgated or ordered in consent with agreement to enter with the individual title of the requirement of the Title II with the rule promulgated and ordered as shown in Title II. Use the commercial process of the chemicals of the mixture of the person knew, but they have the reason to know, but the manufacturing process described in the comments of violation, Section 5 and 6, or the rules in Section 5 or 6, or in any order in action brought under Section 5 and 7. Failure to refuse to ACE to establish remain tech or debate. Submit reports, notify the other information. C. Permit access to a copy of the records required by the Act of the rule. They are under rail to refuse or permit entry with the inspection as required in Section 11. Alright, moving on to Section 16 penalties. Alright, Section 16 penalties, civil. Any person who violates the provision Section 15409 shall be liable to the United States civil penalty with the amount not exceeding $37,500 for the judge violation. Each day that the violation should continue for the purpose of the subsection constitute a separate violation, Section 15409. 2A. For the civil penalty violation 15409, it's up to the administrator of the BMA order to record with the opportunity provided in accordance with the subparagraph of the hearing in the accordance with the 554 with the Title 5 United States Code. Before issuing any such an order, the administrator shall give the written note that the person possessed for the civil penalty and shall under such order, but the administrator proposed the issue so order provides such person opportunity to request within 15 days of the notice received in such person with a reason or hearing in an order, and determine the amount of the civil penalties the administrator shall take into account the circumstance of the extent of the gravity of the violation, respect with the violator, ability to pay, with the ability to continue to do the business, and history of the prior to such violation, their degree of capability, such other matters of justice may require. Alright, the administrator may compromise, notify, modify, remit without condition of any civil penalty with impose with the under section amount with the such penalty finally determined amount with agreed upon, and the compromise may be delegated any sum to the United States as the person over the charge. Any person with a request in accordance with the paragraph of A2A with the hearing and respecting the assessment of the civil penalty with agreed within the order of the assessing civil penalty may fail with the petition. Judicial review with the such order, United States Court of Appeal of the District of Columbia, any or the other circuit of the such person that resides, transacts business. Such petition may only be filed within 30 days before beginning with the day of the order making such assessment is issued. 4. If any person fails to pay the assessment of the civil penalty after my order making the assessment of the become of the final order, and such a person does not follow the petition, judicial review in order in accordance with paragraph J3 in the May before any of the court action brought in the paragraph 3 has entered with any final judgment in favor of the administrator. The Attorney General shall recover the amount of the assessment plug-in interest for the currently prevailing rates for the day of the expiration of the 30 days period referred to in the paragraph 3 of the day of such a final judgment, and as this case be an action brought with the appropriate district court with the United States within such action with the validity of a certain amount of appropriateness of the such penalty shall not be subject to the review. Criminal. In general, a person who knowingly, willingly violates any provision Section 15409 in addition with the lieu of any civil penalty will be imposed under subsection A, but the section shall such violation shall be subject to the conviction and fine not more than $50,000 for each of the day of violation, imprisonment no more than 1 year both. 2. In the danger of the death and serious bodily injury in general, a person willfully violates a provision of section 15409, who know that the time of the violation place of the individual imminent danger of the date of 6 years bodily injury shall subject the conviction or fine not more than $250,000 or imprisonment not more than 15 years or both. Organization, notwithstanding the penalties described in paragraph A of the organization, commence the knowing of the violation of the described in paragraph A, but it shall not be subject to conviction fine not more than $1 million for each violation. Incorporation of the corresponding provisions of paragraph B through F of the section 11.113C5 of the Clean Air Act shall apply to the prosecution of violation under paragraph 17, section 17, specific enforcements and seizures. All right, section 17, specific enforcement and seizures. Specific enforcement and seizure. District Court of the United States have such jurisdiction of the other civil actions to as restraining the violation of section 150409, restrain any person taken with the action prohibited in section 56 of the Title 4 by oral and order section 56 Title 4, compel the taking action required under this action. D. Taking any manufacturer processor with the chemical substance to make sure of the product with the Title 4 manufacturer profit the violation 56 of the Title 4 of the rule order under section 56 and Title 4 distributed in commerce to give the notice of the distributor commerce for the substance mixture of the product with the extent of the reason believe the exertional of the other person in possession of the substance mixture for the product exposed to the such substance mixture product with the two to give the notice of the such risk of an injury with either replace the repurchase of the substance of the mixture product with which either person with the requirement of the directed a civil action described in paragraph 1 may be brought in the case of a civil action described in paragraph A with the such paragraph of the United States District Court of the Judicial District with any of the act, admission, transaction, consolidation, violation, section 15 occurred wherein the defendant is found to transact the business being indicated for the other civil action described in such a paragraph of the United States District Court of the Judicial District wherein the defendant is found with the transaction business of any such civil action process that may be served with the defendant with any judicial jurisdiction of the defending reside that may be found with a subpoena requiring attendance of the witness in such action that may be served in the Judicial District. Seizure any chemical substance mixture of the product subsection Title 4 of the manufacturer process distributed in commerce with the violation of this act. The rule promulgated with the order issued under this act with any order containing substance to mixture should be liable to proceed with again for the process with liable to seizure contamination of these substance mixture products in the article of the name of the District of the United States with the jurisdiction of which substance and mixture of product articles found such proceeding such form is nearly as possible proceeding remedial admiralty. Alright, we're going to cut the tape right there. At preemption, section 18.